Good evening and welcome to RestartED's virtual town hall, the sixth in a series of panel discussions taking place each Thursday throughout the summer. RestartED is a grassroots movement that is bringing together education stakeholders across the country to crowdsource solutions for safely reopening and operating schools in a COVID and post-COVID world. Your contributions are critical, so open the chat room at the bottom of your screen and actively contribute your questions, thoughts, and solutions. And please spread the word of RestartED to your peers in your district and at others. The more minds we have working together towards solution, the better chance we have of succeeding together. The focus of tonight's panel is navigating the legal landscape of school reopening. We have a distinguished group of board attorneys and superintendents with us this evening. So with no further delay, I'd like to introduce our panel. John Comengo is the founder and president of Comengo Law Group, PC, a mid-sized firm with an education law practice group of over a dozen attorneys representing over 70 school districts. John lectures across the country and litigates special education disputes nationally and serves as an adjunct professor at Wake Forest University School of Law. He has written and lectured extensively on COVID-19 related education law issues, and his webinars during the closures have drawn over 13,000 registrants from across the United States. Isabel Machado is a founding partner of Machado Law Group and has devoted her distinguished legal career to the practice of education law. By listening and asking the right questions, Isabel has developed a unique ability to truly partner with clients on creative problem solving. Her collaborative approach fosters understanding and identification of goals and potential obstacles to achievement. Patrick Carrig is a partner with the Lennox Law Firm. He is a board attorney and litigator and has obtained numerous jury verdicts in defense of public schools. He was recently reelected to his second term as the South Central Division Vice President of the New Jersey Association of School Attorneys. Mr. Carrig is a frequent speaker on law school and was recently featured at the virtual Spring School Law Forum on Legal Crisis Management, Pandemic Planning and Response. Mary Robinson Cohen is the superintendent and principal of Roosevelt Public School, Monmouth County, New Jersey. Mary holds a bachelor and master's degree from Bryn Mawr College, a Juris Doctor from University of Pennsylvania, and a master's degree in education leadership also from University of Pennsylvania. As the daughter of two medical doctors who are the only children of medical doctors, Mary had one career choice, medical doctor, with attorney as a fallback if she wasn't good at math or science. Fortunately for the many students she has influenced, Mary decided to pursue her dream of a career in education. After holding various teaching and administration positions, in 2013, she was named Chief School Administrator in Roosevelt. David Rubin is a sole practitioner and of counsel to Bush Law Group. A graduate of Duke University and Rutgers Law School, Mr. Rubin represents public school districts and private schools and has argued numerous precedent-setting cases at all levels of state and federal court system, generating over 50 published opinions. He has served as president of the New Jersey Association of School Attorneys, chair of the National School Board Association's Council of School Attorneys, chair of the New Jersey State Bar Association's School Law and Professional Responsibility and Unlawful Practice Committees, and is a frequent lecturer and author in the field of education law. Mr. Rubin is listed in Super Lawyers Magazine and Best Lawyers in America, and is a recipient of Distinguished Service Award from the NSBA Council of School Attorneys and the New Jersey Association of School Attorneys, and the 2019 Alfred Clapp Award for Excellence in Continuing Legal Education. It is now my pleasure to turn things over to our moderator for this evening's discussion, Dr. Jay Micah, Superintendent of Schools, Matawan Aberdeen Regional School District.
Thank you, Kevin. Good evening, friends, and thank you for joining the RestartED team and our panelists as we spend the next hour discussing the legal issues surrounding the reopening of schools. Let's just jump right in. First question is for Isabel. Isabel, Janice from California asks, there are liability issues around bringing staff and students back into buildings with no clear legal standard to judge what is reasonable in terms of health and safety. How would you respond to that?
Sure, that's a great question, and I want to welcome everybody and thank you for having me here this evening. Just this afternoon, I read a newspaper article where they had really surveyed the community, at least here in New Jersey, and whether or not schools should reopen. And the interesting thing about it was almost split right down the middle, where you had, some community members, some parents who wanted to open school, and teachers and staff members wanting to open schools, others taking the position that schools should not open and that they should remain closed at least until we have a vaccine and this is a little bit more under control. So when you look at those numbers, obviously risk comes to mind. And, I think we're working under very, very challenging situations. But one thing I think we need to keep in mind is to just go back to basics and look at what we have now. I've often advised my clients, reach out for your insurance broker. Make sure that your insurance broker should now be like your best friend. Take a look at what you have existing to protect you in these scenarios before, we get a little bit crazed over, the potential liability. It now would be a great time to really look at your insurance policies. Take a look at those deductibles, what they look like, what you're covered for, what you are not covered for. Like I said, a question for your insurance broker. You really want to take advantage of where you currently are in terms of risk aversion. Look at your current waivers. For example, I had a question the other day, what's our exposure now that we're allowing community members on our athletic fields or on our playgrounds? Do we have to post signs? Well, if you already have signs, they're saying that, community members who are using your fields or your playgrounds are doing so at your own risk, you probably already have that covered. Same thing with look at your forms now. Any kind of waivers that you're using in the district probably already have you covered to a certain extent, for some of the risks that you may have now. In particular with staff, what we are seeing is items that need to be really negotiated with our teachers, our staff members, and things of that sort. Open those conversations up early. Start that collaborative process with your staff members, with your teachers, who about what it looks like to come back into school and hear their concerns. Look at your workers' comp with respect to staff members. Have a good understanding of what your workers' comp insurance, your workers' compensation insurance,
Isabel,
will cover.
If I can interject,
Sure.
A question just came up in the chat room. If a teacher is infected with COVID on the job, would this be a workers' compensation issue?
That is a great question that I don't think I have a clear answer to with respect to that. I would believe, and it would probably depend on your policy, but it would be like, I would think a contagious disease like any other, the flu, and it's probably not covered. But those are all really good questions to find out in advance and to talk to your insurance carrier about it. David, did you want to comment on that?
I just to jump in here, I don't claim to be an expert in workers' compensation law, but one of the reasons why contagious diseases tend not to be covered by workers' compensation insurance is that even though, in theory, a work-related illness is covered, how do you prove that's where they caught it? And even though it may seem more likely that they may have caught it on the job, in order for it to be covered under workers' compensation, which is a no-fault statute, once you hit the bullseye and get covered under it, proving that it was covered there. If you're a first responder working or somebody working in a hospital where it's very clear that's probably where you got it, it might be a different story. I understand that there was a bill introduced by Senator Sweeney or sponsored by him a couple months ago that has talked about expanding coverage for COVID-related workers' compensation claims, mainly focusing on healthcare workers. So evolving area, but even if in theory one believes they caught it at work, proving that's where it happens is going to be the biggest obstacle to overcoming a workers' comp claim, right. I think.
But I mean,
go ahead, John.
Following up on the liability issue, issue. I think it's important. We don't know how we're going to define reasonable, but we've got to know what we know, and we've got to find out what we don't know. And our administrators, our board, although our boards may think, they're not experts in infectious disease. They're not experts in contagion. So what do we know about what safeguards we can put in place for our people? What's the county Department of Health in our various counties and our various states, various regions across the country saying? What's CDC saying? I'm sure we're going to talk about masks at some point. What kind of things can we put in place to safeguard ourselves, our people at all times? Because if there are things that are available and we're not, how do we defend that when there is an outbreak? How do we defend that when there's a cluster? If, you know, the old example, and I saw maybe it was Dave in the chat, you know, slip and fall. If the sidewalk's icy, you better get out there and throw down some salt, or you better get out there and shovel it. Well, you know, what's coming in and what's not? Are we taking temperatures? Why are we not? Do we have masks? Do we have shields? Why do we not? So to me, from a liability standpoint, we better keep our eyes open and put in place what we can, rather than defending against what we didn't do on the back end.
John, if I could just follow up there for a second. You spoke about reasonableness. You gave the example of the ice outside. It's clear what reasonable is there. How do you suppose we're going to define reasonableness through this process?
So I think, Jay, it's important to not create a COVID lane, right? We know what curricular expectations are. We know what working expectations are. We know what the circumstances are in the operations of our schools. And I think we need to continue to apply criteria under those circumstances at all times. Masks, again, for example, school says we want masks on all of our employees. School says we want masks on our students, and then employee comes in and says, I can't breathe. Here's a note, I want an accommodation, or I want a face shield, I want something else that's more elaborate. I think it's important that we not invent some new criteria or analysis, that we plug that into a 504 analysis, we plug it into what we might otherwise consider under ADA or our various states' rules and laws, as we would have a year ago now.
Yeah, and I would like to add, I don't recall if it was John or David who mentioned, we're not experts in this. We certainly aren't. And one of the things I haven't heard yet that I do want to, that is very relevant to this, is also the reliance on the school physician. So, when we need some of these answers, the ability to have this collaborative relationship with the school physician who's going to be giving us some recommendations in conjunction with the local health department. So in terms of what's reasonable, in terms of what we can be providing to our staff and students, that's another person that we really, in today's situation, need to rely on heavily, for certain.
Thank you, Isabel. My next question is going to be for Mary. Mary, do you believe it should be the responsibility of schools to do contact tracing?
So good evening, everyone, and thank you for including me on the panel. As a superintendent with a legal background, I like to ultimately, and I would like to say to everyone, my attorney happens to be here. My school board attorney is David on the panel. And I think that everybody should rely on their school board attorney for advice. Ultimately, those of us who've gone to law school know that you have a fool for a client when you treat yourself. However, having said that, I've been listening very carefully to our health officials in New Jersey. New Jersey is a home rule state. So of course, if you have almost 600 districts, you probably have almost as many health officials. And recently, our health official told us, he made it very clear to us as superintendents, that he would be responsible for the contact tracing. And to go to John's earlier point, I'm an expert in teaching and learning. I'm not an expert in medical care. I'm not an expert in the medical field. I certainly know the HIPAA rules. And I really, as a superintendent, don't want to get involved in what I'll do is I'll treat the child as I would any other child. I want my school nurse to sit and ask the questions, isolate the child as we would in any other situation. And then ultimately, we're hopeful that the parent will take the child to the pediatrician as they would. The pediatrician will return the information to us, and then then we will send that information on to the health official to do the contact tracing so that we've had a hard enough year in teaching and learning. I don't welcome doing HIPAA tracing as well.
Thank you, Mary.
I just had a question for just following up on what Mary said. I mean, is there one thing that we can all agree on here, that as I read the roadmap manual, I don't believe it has an expectation that school districts are going to be doing contact tracing. I think the expectation is we're going to somehow coordinate with our health department. So I don't think anybody out there, at least from New Jersey, should be thinking that there's a mandate that we be doing this.
Thank you, David.
I would agree with you, David, from my reading.
Patrick, Yvette from New Jersey is interested in hearing about the legal rights of teachers that may have pre-existing conditions and how that affects them coming into school.
Thank you. That's an excellent question. It's certainly on the minds of everyone, and the paramount concern of anybody operating a school district is always to keep everyone safe. And so coming back into school, we're thinking immediately of our students and our staff and how to keep them safe. And when people come into the school building, staff members and students, they're going to come in with pre-existing conditions, with things that are recognized under the law as disabilities. And to echo what my colleague John said earlier, we have things in place right now to address those and evaluate those. And John specifically mentioned the ADA and 504. And so for particularly staff members that are going to be coming into the school year with pre-existing conditions that would meet the definition of a disability, there is a process that exists already to address those. And so what generally is required under the ADA, which is a federal statute and applies nationally, would be to engage in the interactive process with that employee. And employers are entitled to information to figure out what exactly that pre-existing condition is or what that asserted disability is, determine the nature and extent of that disability, how it would affect them, and make an informed decision working with that employee through the interactive process to figure out what a reasonable accommodation would be. And the interesting thing about reasonable accommodation is it's not necessarily what the employee desires specifically. It's actually not necessarily what the employee's physician wrote on a piece of paper saying that they have this condition and they should get this. It's a reasonable accommodation, and there's no bright line rule as to what that may be in any particular circumstance. So it's really a case by case basis. I think that as the other panelists have indicated, that it would be wise to consult with your district physician. I know in our districts that we represent, because a large part of our firm does medical malpractice defense, and that's been a large part of my practice over the years, we oftentimes will consult with specialists in the area to help us in particular situations when it's a nuanced situation. And so here, where most district physicians are oftentimes family practitioners or internal medicine specialists, this might be a time that you want to consult with them and say, well, is there an additional expert in the field of infectious disease that we might want to consult with for any particular type of pre-existing condition to determine if there is a reasonable accommodation other than work from home or other than disability leave. And those are things that I think would be good to determine before we get to the school year. So we have some ideas in place, recognizing that there is a strong possibility based upon the list issued by CDC as to what pre-existing conditions could be the most concerning when it comes to COVID-19, that the districts have an idea as to how to address those short of work from home, short of a leave, which is a huge concern for districts when it comes to continuity with their students and also with costs.
Thank you, Patrick. Mary, if I could just follow up with that, are you starting to look at ways, if there is a large number that are out, on how the school day would go if there are a lot of teachers that can't come in because of pre-existing conditions?
So I have a really tiny school district, and I have surveyed my teachers, and so far everybody is pretty much willing to come back. I mean, there is some concern about teachers who have family members and how that's going to be handled if you have a family member with a compromised immunity system. However, you know, those of us in the superintendent business realize that it's very touch and go and that the information changes on a daily basis. So most of us are making in-person plans as well as hybrid plans for virtual instruction. So I think that there would be a place for a staff member, obviously, probably all staff members, I'm asking them to be prepared to go virtually at a moment's notice.
Thank you, Mary. This question's for Isabel. Isabel, David, go ahead.
I think it's probably worth noting here that, you know, in addition to accommodating people who have legitimate health needs, either because they already have a condition or are elevated risk for exposure, you know, let's be honest, we're going to be faced with a lot of people who have no condition other than being human beings and being nervous.
Mm-hmm.
And I can tell you that in a lot of districts, and certainly some of the ones I'm working with, you know, the 800-pound gorilla in the room are going to be folks who are just scared to come back. If they feel forced to come back or compelled for fear of loss of salary or insubordination or what have you, their mind's not going to be in the right place. I think some, you know, legalities aside, I think some thought needs to be given to how we're going to deal with that. Whether we're going to, for those people who have no legitimate legal excuse at all, I think we're going to be getting some requests for unpaid leaves of absence, things that may be negotiable with the union. So let's not just focus on those folks who have the demonstrable medical needs. There are going to be other folks who just aren't going to be ready to come back and have no legal excuse. So we're going to have to figure out what to do about it.
Thank you, David. Isabel, back to you. We received a lot of questions surrounding IEPs and 504s and the services that were not able to be provided over the last 3 months. Could you speak to what that might look like down the road and how we go about making up those services?
Sure. So, I mean, this is, you know, something that school districts are going to be struggling with for a while. So we've had a period of time, most states, I believe, have been closed for significant, meaning schools have been closed and instruction has been done remotely, whether it's done through whatever the platform's being used, but it's being done remotely and virtual. And especially for our more vulnerable students, those either with a 504 or an IEP, they haven't been getting the same level of services that they would have otherwise been entitled to under, or let's say, an IEP document. So once schools are able to open, we really do need to go back and have our child study teams, our IEP teams, our special services departments really go back and take a look at our students to see what level of regression that they've had over this period of time. So until we're actually fully operational, or at least in-person services, that's going to be pretty hard to determine. But what I have been saying is we need to look at a couple factors, and there are things we can be doing now for our students to start this process going. Meaning, if I'm looking at a particular child with an IEP, I want to know what the typical rate of progress is for this student. So let's take a look at and go back to the last 2 years and actually look at how much the student has progressed. So for example, if you have a student who has a reading disability, what is the typical rate of progression for that particular student? And then try to, and I recommended to the extent that we could, I know we had closures that happened really quickly, but to the extent possible, try to measure that baseline prior to the closure, so you knew where the student was prior to going virtual. And then once we're able to assess the student, how much was lost? How much was that regression? We may have students, I mean, I can tell you, I have students in districts that I work with that actually the student did better virtually for whatever reason. The instruction, you know, that student's disability or whatever lent itself to virtual instruction. So not all students are going to be entitled to compensatory education. I think the most important thing we need to remember is that it's not a one-for-one analysis. So it's not a student missed, you know, 20 sessions of occupational therapy, so we need to make up 20 sessions of occupational therapy. The measure really is, where should the student have been given the normal rate of progression for that particular student? So all of this is individualized. Much of the IDEA, all of the IDEA is really individualized, but this analysis has to be very individualized. And where should that student have been had it not happened, had the COVID not happened? And that's what we're going to use to, you know, say, this is what we owe you in terms of compensatory education. But it's very difficult, very individualized, and we're going to have to look at all of these little factors. But I encourage everybody to really look at that now. To the extent that you can, look at that past history for that particular child and go from there.
Jay, if I could jump in on that also.
Absolutely, John, go ahead.
You know, it's almost like we sense a feeding frenzy in the special ed bar with some thought that there's going to be an automatic award of comp ed for every student with an IEP. And that's just not the case. You know, I love to cite our musicians. Lou Rawls hit it in the 70s and he said, shoulda, woulda, coulda, right? My dear father loved Lou Rawls. What could we have done, right? Our governor in New Jersey shut down schools. Across the river in Pennsylvania, shut down schools, right? We can go across the region where all of our superintendents and other educators are tuning in today. Schools shut down. So what could we have done? And I think the question of regression, Isabel makes a great point when we talk about looking back historically and seeing what regression there was and was not. I am encouraging our teams to be mindful that we got to look at progress. We got to look at what we're anticipating, but let's not also think that there's some requirement. We open up schools September 1, that we sit down and calculate some quote unquote award of comp ed. That's just not the reality. US DOE is not saying it. I'm not aware of any state's Department of Ed, which by regulation are telling teams to do that, number one. Number two, kind of the flip side of the coin, and I noticed in the chat Dr. Todd Fay asking about FAPE. And one important cohort that we're encouraging our schools to keep in mind are our multiply disabled students, our students on the spectrum, particularly those most severely impacted, who have been largely disenfranchised. You know, those students who can't participate in synchronous instruction, who maybe have not been able to, with a lack of support in their home, participate from asynchronous instruction. If you're going to go down a road of a hybrid model, which I'm hearing most of our colleagues talk about, what can we do for this cohort that is 5 days a week to really plug them in and get them back to where they need to be, ought to be, and you know, again, shoulda, woulda, coulda. We need to make up gains in that group, and I would certainly encourage our teams to spend a lot of time and effort supporting those students most at risk.
If I can just comment, just jump on what John and Isabel had said here. You know, people throw this term regression around very loosely, and I think that they are mixing and confusing a couple of different concepts here. Regression is the concept that we typically bring into the discussion when we're talking about whether someone needs extended school year over the summer because they're going to regress too much by September. Compensatory education, at least as I understand it, is a remedy for someone who has been deprived of certain rights under an existing IEP. It's to compensate them for essentially a breach of contract, if you will. And to John's point, you know, our IEPs that we had in place last year were, in a sense, the contract that we had with these families. Just because school was shut down and we had to deliver instruction in an unorthodox way, does that necessarily mean that we violated those IEPs? Because if the answer is no, then you don't get to comp ed, even if in theory children regressed. If there was a massive snowstorm or Hurricane Sandy and schools were closed for a significant period of time, just because children may not have progressed as far as they would have had school been operating normally doesn't mean we violated those IEPs. So keep the concept of regression separate from the concept of comp ed. They're two separate and distinct issues.
And if I may, very briefly.
Yes, Pat.
You know, the best defense in special education matters is actually a non-legal defense. It's a trusting relationship between your special education's department and the parents of special ed and guardians of special education children. And one of the unique things about this moment in time is that we are all experiencing this simultaneously. It's not discriminating against anybody. And so as you know, educators are going through the same process, and they are parents themselves, special education students and their parents are experiencing what we've all gone through with the shutdowns and our fears and concerns. And I think it's a moment that they can share in that experience and work on and continue to build that trusting relationship and demonstrate their commitment going forward to make it right and to make it work under the circumstances that we're in. And I think that non-legal defense is going to be the best offense and defense going forward as we approach the special education cohorts within the school districts.
Thank you, Patrick. As a follow-up to Patrick's point, Mary, as a school leader, how do you help foster that within your district?
So I did mention that in the chat. I think that that is, first of all, it's key to have a good relationship with your association president. It's key to have a good relationship with your board. And it's also key to have a good relationship with your community at large. And I think that that's, you know, that's built with trust. That's built, that doesn't come just out of this event. There's a foundation that's built there. There's, you know, there are going to be wild questions and everybody's nervous about this. But I think if this is where leaders have to lead, and you know, what the foundation that you've laid will hold you in good stead. And for people who haven't been doing that, I think this is a big wake-up call that you say, wait a minute, what's going to happen next? I really do want my parents and my community to trust me and to believe. I tell parents all the time, your child is my child. Okay, that's what I want for your child is what I really wanted for my own children and would want for them in front of me. And I stand on that, and I believe that. And that's how you build it. People can spot a phony any you know, a block away. So I think you really have to work hard with that. And you really, I can't emphasize enough how you have to work hand in hand with your association on this. Your association president. I'm in constant contact with my president as we go forward.
Thank you, Mary. Well put. Next question is for David. We have viewers on from many states, but I'm going to use New Jersey's roadmap to get back to school as an example for David. It's not a statute or a regulation. Does it have the force of law, that document?
Well, that's a good question. First, I want to hire John Comegno's lighting director because he's looking great, and I'm looking like Bela Lugosi over here. I don't know what's going on with my lamp.
I wasn't going to say anything, Dave, but.
Well, so what is this document? We have the statutes, Title 18A, that create school districts and tell us what our rights and responsibilities are. We have an executive order in March that says schools are shut down. Somewhere out of the blue, drops down out of the sky this thing they're calling a manual that has all sorts of instructions about what we're supposed to do. As you point out, Jay, it's not a statute. It's not a regulation. The State Board of Ed knows how to adopt emergency regulations when it wants to. It has over the past 5 or 6 months. So what is the legal effect of this manual? The answer is not sure. You know, I'm not sure if I have to advise clients, but the reason why I'm not making an issue of it, I mean, there are times where we make an issue of these things when things that look like rules and regulations really don't have the force of law and they're getting in our way. But this goes back to a question you asked earlier. For want of anything else, at least we have something that at least claims to be some sort of a standard, where we were completely adrift until this came along. And whatever you might say about this roadmap to, around my office, we call it the roadmap to nowhere, and I was somewhat in jest, but you know, it provides, it's a roadmap that at least gets the discussion going, let me put it that way. It does have some standards in there. For example, page 9, school districts must follow CDC guidelines. That's a standard, and that's just a starting point. That's the ground floor of what we're required to do. So, going back to the earlier question about liability exposure, as someone pointed out, you know, in our system of justice here in New Jersey, we're a fault-based system of liability. Unlike workers' compensation, where it's strict liability, in order for a district to be liable in a court of law for somebody getting harmed, somebody has to show he did something that deviated from some standard. Well, at least here we have some standard that at least is tied into what the safety conditions are. But I think there are going to be other potential liability issues from some very creative lawyers out there that are going to go beyond simply the health and safety issues, and that are going to be concentrating on the quality of the education and whether children are being deprived of their educational rights as a result of what's going on. And here's where I think they're going to run into a little bit of a roadblock. You know, if you sue a lawyer, if you sue a doctor, the first question that has to be answered is, what is the standard that they deviated from? And in the professions that we practice in, or doctors or accountants, there are established standards from which a jury could determine whether the professional has deviated from it. Years ago, somebody tried to bring a case in New Jersey for something called educational malpractice. It happened to involve, I think, a resident in a hospital who got sued, and he turned around and sued his own hospital for saying, you didn't educate me properly, and you turned me loose on all these patients. And when the court stopped laughing, they said, there can't be a case for educational malpractice in New Jersey because you can't get two experts in education to agree on much of anything. How can you have a standard that people can be sued for violating? So I think when people are concerned about being sued for not providing the quality of education kids need, I think you can rest easy there. We're all going to do the best we can. And I think, as Isabel pointed out earlier, everything in life comes down to insurance anyway. So make sure you're spoken to your insurance.
Thank you, David.
And can I just
Go ahead, Isabel.
piggyback on something? I think the problem, and to David's point, the problem that this is not, you know, an emergency regulation, a statute, it's, you know, a manual, some kind of standard. And I think you alluded to this as well, is that if you speak to different superintendents in the state, even if you speak to different executive county superintendents in the state, they can read the exact same line and have two different interpretations of it. So what is happening now is that this standard that we're calling, or the roadmap, even from, you know, to a certain extent, the representatives from the Department of Ed are reading it and have very different interpretations. And as school leaders are trying to maneuver through this unknown world that we're in now, it becomes very, very difficult to, yes, it's good to have a standard, but unlike a statute in 18A that we can all look at and say, okay, that's what the, you know, what this means, and maybe there's some case law behind it. This is very difficult to interpret, and you have different interpretations between attorneys, you have different interpretations between school leaders, you have different interpretations within the Department of Ed itself. And that's just a logistical problem that I think we're working through right now as a state.
Thank you, Isabel. Patrick, I just want to follow up. David spoke about, you know, liability in his last few sentences there. And we received some questions. You know, we're told to have an isolation room, you know, preferably next to the nurse's office. Do you see any HIPAA issues with that? You know, a staff member walking by, a student walking by, and they see someone escorted into that room. What do you think about that?
So the guidance that we're receiving in New Jersey upfront indicates that we have to have something along the lines of a quarantine room or an isolation room. There are mandates upfront with respect to temperature checks coming in when the students first arrive, symptom checks when they first arrive, and just on an international basis in terms of the countries that have reopened, all of them reopened with those checks upon entry. So they were doing temperature checks upon entry. They were doing symptom checks upon entry. And that is clearly geared towards removing students that have those symptoms and pose a threat. And so one of the key pieces of legislation that exists is the ADA, and I mentioned this earlier, but what exists under it is a standard called the direct threat standard. And normally you can't discriminate against a person that has a perceived disability. And so if you perceive someone as sick, in theory, you're perceiving them as disabled, and therefore under the law, generally you wouldn't be able to discriminate against them or treat them any differently. But under these circumstances that we're under now, COVID-19 very likely presents what's called a direct threat. And direct threats are those that cannot be addressed through reasonable accommodation. And so existing EEOC guidance that's available on their website indicates that employers, and I would say that can be translated to the schools, are permitted to inquire of people to determine if they have symptoms, and they're permitted to exclude in situations when those symptoms present the possibility of COVID-19. So when it comes to isolation rooms, because we're doing that in the first place, I wouldn't be concerned with violations of HIPAA. I think, in my personal opinion, with respect to HIPAA, it's of questionable application to school districts in its own right, because it's geared towards doctors that bill for their services and have very, very specific requirements with respect to medical record keeping. And so I hear HIPAA frequently thrown around with respect to schools and the protection of medical records and confidentiality. But in reality, there's a different basis for confidentiality of medical records with regard to schooling and student records that's really not coming from HIPAA because I don't believe it necessarily applies in the same way. So to the extent that there are concerns, I understand that and respect that. At the same time, though, because COVID-19 very likely meets this direct threat standard, I think schools are empowered to take actions right now and use an isolation room or use a quarantine room to the extent that they can. I think that some of the things that the schools are experiencing with respect to that is a lack of space, number one. which is a huge issue because if you're trying to get kids in school but socially distance those children, you're using as much space as possible, but now you have to use additional space, which is your isolation room. A secondary issue is, okay, you have a student or more in that isolation room. What staff member is going to be supervising those students in that class? I think that is a really difficult issue because one, do you have any volunteers whatsoever? And two, if you actually don't have any volunteers, then can you direct a staff member to go and be the person supervising those students? Because you're going to need somebody doing it. And these are challenging issues that I think districts are facing when it comes to that unique area with the isolation room, and then the difficulty of having children picked up, you know, timely or by the end of the day, whatever it may be.
Thank you, Patrick. Mary, do you have space in your building for such a room?
I do have space, but I would disagree a little bit with the, first of all, I don't think the road back requires a temperature check. And I think that we as superintendents have had that discussion. If the temperature check is to be done, shouldn't it really be done before they get on the bus? If you have a district that buses. So there's that. In addition, I think that we will isolate, I will isolate them, but I'll isolate everybody in the same way. I'll have my nurse staff that room so that there's no, I don't really want to take the chance of the wildfire that's going to go through the community when somebody suspects that somebody has COVID. And we don't even know if they do until they've actually gone out and had their pediatrician make the determination.
Thank you. I have a question for John. David, go ahead, then I'm going to...
Just I saw a question scrolling through the chat here that I think should come up sometime, time permitting. Someone asked the question about either what the manual says or what are we going to do with folks who just are not comfortable sending their kids to school? What duty of accommodation do we owe to them, even if they don't have a clinically diagnosable medical condition? I need to tell you, I was minding my own business yesterday when I got texts from 3 superintendents at the same time who were all sitting in a meeting of one particular county superintendent who had indicated to them that contrary to what most of us believed, the department was saying, at least as of early yesterday morning, you cannot provide parents with the option to simply keep their children at home. This was the message that one county superintendent was telling folks after people had already put plans together that were giving parents that option. That's how a lot of people read the manual. I'm told that with the blowback that happened during the course of the day, the department may be rethinking that. They also said in that same meeting that school districts were prohibited from shutting down for a day to have a complete virtual day, that kids had to be in school, at least some kids, every day. I'm told they retracted that by the end of the day. So in terms of what the manual means and who's interpreting what it means, it's changing literally from morning to night, yesterday being an example. So for those of you that are finalizing your plans now, make sure you get some cover from your local county superintendent and get them on record as to what they say you're allowed to do on that issue in particular.
I think fluid is the word, right?
I've got a few others, but.
Yeah. John, I have a question and it's up in the chat room. Let me talk to you. Yesterday, I believe, CDC was ordered to flow all the reports through the president. What do you think about that from a constitutional standpoint?
I'm a big fan of all Goya products.
Yeah, exactly.
I think they retracted that about 2 hours ago, if I read the news correctly.
I don't think when we talk about expertise that I'm qualified to talk about where the flow of federal information ought to go and ought to not, other than to say that we ought to be absorbing what information we feel is valid. Our school administrators ought to be absorbing what information they feel is valid, whether it be from CDC or from state authorities or county or local authorities. And again, back to this issue of liability and awareness, and I just commented following up with Patrick. I loved a number of Patrick's comments talking about this issue of a symptomatic student. I agree with Patrick, and I think this issue of HIPAA is often a red herring. Even the same with FERPA compliance. Let's focus on, folks, what's important. You folks have so much to figure out from a scheduling standpoint, from a logistics standpoint. Let's focus on what's truly important. And if we've got a symptomatic student in front of us, I'd be more concerned about keeping that student safe and those folks around that student safe than I would be who sees that student, how long they see that student, or where they see that student. And again, on the back end, if we don't move quickly and we don't move consistently with what protocols our school physician and others have established in the beginning, and again, we have a cluster, we're going to have a heck of a time defending this.
Absolutely, I agree. Thank you. Along those lines, in a way, Isabel, what are some policies that will be changing in the next month for district as we look to open up school in September?
Right. So well, we know at least through the roadmap that we're talking about that one of the policies that the districts have to adopt is with respect to the cleaning procedures and how they're going to, disinfect the classrooms, disinfect the buses. And so a very specific, requirements for that. Again, I go back to the school physician. A lot of our school physicians are weighing in on this, on what would be the appropriate chemicals, the appropriate disinfectants, the solutions that should be used, and they have definite opinions on this. So those policies need to be addressed. That has to be a board policy. With respect to other policies, I think Mary brought up the bus and temperature checks. I think the best thing that any district can do is make sure that the parents are aware of what the policies and procedures are, even if it's not a formal board policy. So if you are doing temperature checks before a student gets on a bus, maybe an expectation that if your child can't be left unattended, that you need to wait until that child actually gets onto the bus. Things like that. But the idea being that you want to make sure that the parents are aware of what your school specific processes are, so there's no surprises. What happens, to Patrick's point, if the student, you're doing the temperature checks and the student is going to be isolated? What's the expectation from the parent in terms of pickup and what's going to happen? I think the communication piece that Patrick mentioned is going to be important in terms of our policies and procedures to make sure that everybody really knows what's going to happen in all of these circumstances. What are the processes, the protocols, should your child, exhibit a symptom of COVID, things of that sort. We're going to have a lot of policy changes, and I think it's a learning process as we're going through this. I have to tell you, I have never learned so much each day, every day, as I am currently learning now. Every day I wake up, I learn something different, something changes. We're looking at things, a million different ways. We're trying to find analogies to things that have happened in the past that don't fit neatly into this box. So I think we're going to have lots of policy changes. Those are the ones that come immediately to mind, but it's going to be a learning process. It certainly is.
Thank you, Isabel. Mary, to that end, do you plan on making those policy changes in the upcoming months prior to school starting?
Absolutely. I'm waiting for the Strauss. We subscribe to Strauss. I'm waiting to see what their policy is. I've gone through through the document, and we will communicate them to parents. The directive from the Department of Education was that we have to have them out a month before school opens. So with our school opening on September 8th, that'll be by August 8th. I think what complicates everything is the politicization of this, that it's become a political issue.
Has it become political, Mary? Has it become political?
Just a little bit. And that parents, I try to listen to all of the news reports because I think that my parents are listening to all of the various news reports. So, and I try to, as a superintendent, anticipate that those questions are going to come up and that I'm going to have to deal with them. I think though, as school leaders, we're called on we're called on to make sure that we have cleaning protocols in place, that we have what we know, the best protocols in place from the medical standpoint. And from there we go, and that we evolve. This certainly evolved very quickly for us in the spring. As school leaders, we're all in New Jersey, for the most part, a little disappointed that we haven't gotten more direction from the Department of Education. But by the same token, it's a state where we have these little districts and we can do because of home rule. So I hope that answered your question, Jay, but I think
absolutely
that
Thank
we're
you.
evolving, but trying to stay ahead of the curve.
There you go. Thank you.
Can I just add something to what Mary said? It just struck me as well. Not only are you looking at all of these different pieces from the parents and, what they're hearing. But to a certain extent, all districts are judged against their neighboring districts. So I know what I'm hearing a lot when I get the phone calls from, my clients is, well, this district is doing this, why are they doing this and we're not, or, and the parents are making those phone calls as well. So I think the home rule is there, but I think it also presents certain challenges for school districts, because any school district is always held in comparison with others, in particular neighboring districts, right?
Thank you. Speaking of challenges, Isabel, John, you talked about masks before, and they come up almost every day in discussion. Is it legal for a district to mandate the use of a mask?
Jay, let me ask, is it legal for districts to regulate how wide a tank top can be? Is it legal for districts to mandate how long a skirt has to be? Is it legal for districts to say you have to wear a coat if you're going to go outside on the playground in December? Is it legal or appropriate or safe under the current circumstances with what we don't know to permit our students to walk without masks? I think those are all equally important questions. I would say yes, it is legal. And I would also say that we've got to be really mindful of the consequence if we don't impose what is accepted principles of safety, using PPP and other things. If we're not, how are we going to defend against that? And we've got to be real careful about exceptions swallowing the rule. Patrick noted very clearly before certain ADA and 504 principles. I don't know if it was Patrick or my friend David who noted that a note in and of itself isn't a pass, and our superintendents do a really good job today. Our 504 teams, coordinators do a really good job today to make sure that we're confirming what that note says and why. So someone rolling in with a note that says, I can't breathe, I've got respiratory issues, and this could be employee or student, that doesn't automatically mean that they don't, quote, have to wear a mask. We've got responsibility for their safety. We've got responsibility for the safety of others. I'm hearing that surgical masks are more breathable than cloth masks. Surgical masks are cheaper. I'd recommend that we have boxes of surgical masks and pass them along for a student that has concern about the ability to breathe through a cloth mask. And the same with employees. Or alternatively, what about shields? And the role that shields can play. So anyway, very long-winded way of saying yes, and I think we ought to, and if we don't, I think we've got to have a real clear reason in explaining why not.
So if I could just support what John's saying there, I think there's one area with the law, there's actually some law that helps us. We're not talking here about how long somebody's sideburns can be, which seemed to be the big constitutional issue when I was in high school, or how low skirts or short skirts could be. We're not talking about those sorts of civil liberties issues here. We're talking about safety requirements in the midst of a national emergency, and there is a substantial body of law that says in that situation, government officials have a huge amount of discretion to impose regulations as long as they're not arbitrarily applied to one group but not another. So I think the short answer is we can say with confidence, of all the things we can't say with confidence here, that we can confidently say yes.
I agree with you. My issue is the supply chain and having the ability to have enough in place for when September comes around.
Right.
And that is a huge question.
And I'll just
how long
add,
will Ruben's sideburns? That's what I really want to know.
And I'll just add, I think the concern with the mask, at least, I do a lot of special education, as you said, is that we have some significantly disabled kiddos who, whether or not it's because of their disability, their anxiety even prior to COVID, their behavioral disability. I mean, I can think of numerous, probably thousands, that would be impacted by the wearing of a mask. We have students with sensory issues. And I know that, we all know we have to make exceptions and really, accommodate those students as a result of their disability. But, in talking, and Mary, I don't know if you have this experience, but in talking to some of my clients, I mean, we have classroom classrooms full of students who we know are going to have difficulty keeping these masks on. Then we start talking about, well, if the students aren't going to keep the masks on, what can we do to protect the staff members? Are we looking at maybe, a stronger masks with a shield, with, partitions, with, these are all discussions that are happening. And these kiddos are also the kiddos that probably need the closest attention, meaning closest in terms of distance. So they're probably the ones who benefit from some of the instruction that is hand over hand, or some of the instruction, or even the paraprofessionals or the aides who really kind of have to almost be on top of them to keep them safe in the normal course of business without COVID and masks. So
and
I think
also, Isabel, if I can interject, they're also the ones who need to be in school the most.
And they're the ones who need to be in school the most. Yeah, right. So I don't have really good answers to that, but I just wanted to kind of throw that out there. When we're talking about masks, I think a real relevant discussion and challenge for our school leaders is our special education population.
Absolutely. Thank you, Isabel. I agree. As our hour is winding down, I just want to give everyone a chance to give some closing thoughts. I'm going to go around the horn and start with Mary.
So I guess that I look at all of this, I do start with the end in mind, and I think we were talking a little bit about that. You do want to think about where are you exposed for liability and reason backwards from that. And in addition, I guess I would also underscore my point about this is the time. If you haven't built partnerships and relationships as school leaders, you need to do that. You also need to stand firm as a school leader. I'm in a superintendent's group, and one of our speakers recently said, you have a lot of balls in the air, and if they're not colliding, you're not doing your job. So I'm thinking that we're doing a good job this time around.
Thank you, Mary. Patrick.
So I mentioned earlier, I'm a litigator, and so just like Mary said, I work backwards, and I think of the closing statement that I'm giving, or the closing argument that I'm giving to the jury, when I'm actually encountering that decision in the moment. And when you're a board attorney, you're encountering it at the moment. And so if you can start asking yourself those questions, does this sound reasonable? If I'm telling a group of 6 to 8 to 12 of my peers from my county and explaining what we did at that time, does it sound reasonable? And I think that in many decisions, that will be your guiding principle in how you address decisions with your staff and your students going forward. And then the only other thing I would say is this, and along those lines, does it pass the headline test? And when you're a public school leader in New Jersey, and you have a million local papers out there that love to publish what the school board or the superintendent recently did, put the two actions or the different courses that you could take out there and say, okay, which one reads best as a headline? And that might be the way to do it. So I would say, when in doubt, apply the headline test.
Thank you, Patrick. Isabel.
So I'm going to forward look on this, and I always think to myself, when this is over, what does our new world look like, and what can we take from this? And two points come to mind. One is technology. We have just been fast-tracked right into anybody who didn't want to use it before is now using it. We've been fast-tracked into the world of technology and doing things a little bit different. And I honestly think this, this may actually be a great thing for education in terms of the use of technology. We have been forced to think on our feet. We've been forced to think quickly. We've been forced to use technology in ways we never thought possible. And I think the benefits of that are going to show in terms of how we use technology in education in the future. We're thinking out of the box.
Yep. Thank you, Isabel. John.
I'm so tired of hearing the word unprecedented. We are in extraordinary times, right? But I would encourage everyone, every educator on the call, every chief executive educator on the call, chief academic officer, here in our room tonight, don't think there's a COVID lane. The song remains the same. The circumstances are different. The risks in many ways are different. Let's not create new criteria. Let's not engineer new thinking or exceptions or procedures or process that are unnecessary when the standard, the criteria, certain process exists that ought to be applied. Because when we do that, we're acting in arbitrary ways and we're going to jam ourselves up. And thank you for having me, Jay.
Thank you, John, for being here. David.
Well, just a couple of observations, sort of unrelated, but in no particular order. The one thing that has really dawned on me that I already knew was there, but I'm now dealing with and recognizing more on a daily basis. Boy, if we ever didn't realize what a digital divide we had before, certainly we realize that now. And while it's always been there, here it's being realized in a way that is having day-to-day effects on people that we deal with, people that we know. So that's one impression. The second is that, and let's all be honest, our generation was not wired for this. Maybe you were, Jay, you were in the military, but for most of us, this level of stress, anxiety, and being in a constant state of crisis for months at a time is something that we're not used to. But to kind of say in my own way what Pat was trying to say before, and this is a test I give to my clients, when you're making decisions about what to do on a day-to-day basis and you're unsure where to go, pretend you're on that jury 2 years from now that's looking back on what you're being sued for what you did 2 years earlier. And if you can say as a member of the jury that what you did was reasonable, I can give you no better measuring rod. Thanks.
Thank you, David. Thank you all so much for being a part of tonight. I ask that you please join us next week when we discuss the topic of facilities considerations for reopening. Good night, friends.
Good night.